After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the major questions doctrine still has vitality in understanding the best meaning of the statute as Loper Bright now requires.
What's the public rights doctrine?
So most recently, the public rights doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Jarkesy, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms.
Welcome back to the channel where we break down the biggest legal stories rocking the nation. Today, we're diving into the blockbuster Supreme Court decision that just shattered a cornerstone of modern administrative law. Loper Bright v. Raimondo didn't just make waves, it brought a legal earthquake, overruling the Chevron doctrine and redefining the balance of power between courts and federal agencies. What does this mean for government agencies? For the courts? For you? Stick around and don't forget to slam that subscribe button so you never miss a breakdown like this.
Tell me about the Loper Bright case.
Sure, so Loper Bright is the case that overruled the Chevron doctrine. And the Chevron doctrine originally required that if there is an agency statute that governs an agency's conduct, the agency gets deference, meaning a thumb on the scale, when it's interpreting what that statute might mean as it's carrying out its duties. Loper Bright determined that that framework was inconsistent with the Administrative Procedures Act, and instead that moving forward, courts should decide all of those statutory interpretation cases as a de novo matter, meaning the agency doesn't get any sort of special head start.
How much deference did a federal court have to give to an administrative agency under the Chevron doctrine?
Sure. So the court would originally make a step one determination about whether the statute was ambiguous or not. That's in the eye of the beholder sometimes. But if the court determined that the statute was ambiguous in the relevant sense, meaning it didn't resolve the question the agency was facing, it would defer to the agency's view of the meaning so long as the agency's interpretation was well explained and reasonable.
What's the relationship, if any, between Loper Bright and West Virginia v. EPA?
So that's a fascinating question. I think, West Virginia versus EPA applied Chevron, but said we're less likely to find ambiguity, and indeed Congress needs to speak clearly if the agency is purporting to resolve a matter of, in the court's terms, political or social significance. And following Loper Bright, of course, there is no deference. And I think some have commented, including Justice Barrett, that the best way to think about West Virginia versus EPA in interpreting statutes is that it informs the context of how we understand what the statutory terms mean in the context of an agency delegation. So the fact that the agency is purporting to carry out its duties might resolve whether or not the particular question is sufficiently clearly delegated by Congress.
If you're into legal thrillers unfolding in real time, hit subscribe right now. The Loper Bright case tossed Chevron out the window. The Supreme Court said courts should now interpret statutes on their own, from scratch. That's their de novo standard.
That just seems to me like a distinction without a difference. I mean, doesn't Loper Bright wipe out the need for West Virginia v. EPA? Why do we still need a major questions doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the major questions doctrine still has vitality in understanding the best meaning of the statute as Loper Bright now requires.
What's the public rights doctrine?
So most recently, the public rights doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Jarkesy, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms. And so if you have a matter like that, that's the type of matter that needs to go before a jury to ensure that the Seventh Amendment's jury protections are abided. By contrast, if there's an internal administrative process, Social Security benefits, things like that, that looks more like a public right that wouldn't have existed but for the government granting it.
And what did the Supreme Court hold in, was it Jarkesy?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission actually looked more like common law fraud claims and more like property-based claims that must be tried to a jury in court and cannot be vested in the in-house SEC proceedings to be tried before an administrative tribunal.
My time is done. Thank you, Professor.
Okay, against my better judgment, Senator Schiff, I promised Senator Schiff, because I skipped him in order, I promised him one more question. All right, Senator. This gavel will never come to me again, though, if you ask more than one question. So I'll hold you to it.
Well, I've got the
This is
Well, there we go.
this is just in honor of Mike Lee's birthday.
Yeah, be sure I understand, Professor. District court rules in a case. You got plaintiff or defendant and defendant. You're representing the plaintiff. Your plaintiff is very unhappy. Are there any circumstances under which you would advise the plaintiff to ignore the federal court order?
So, of course, as a judicial nominee, I would be trying to
I
issue
don't want to
proper
split
orders.
hairs here.
No, the normal process is to
I know what the
seek
normal
appellate
process
review.
is. Can you
My-
think of any circumstances where you would tell the plaintiff, nope, you don't pay attention to this federal judge?
So the problem with answering it that categorically is that there are potentially some very extraordinary situations you could imagine
Like
that
what?
could come before me as a
Like
judge.
what?
So this is a subject of
I'd be
tremendous
careful
scholarship.
there. I'd be real careful.
All
there,
right,
Professor.
Senator. All right. I promise you.
Agencies don't get a head start anymore just because they're the experts. It's the court's job to decide what the law says. Period. Why? The justices said Chevron clashed with the Administrative Procedure Act, which governs how federal agencies work. This is a massive shift. It's like telling the refs they're not allowed to consult instant replay anymore. They've got to call it as they see it. We're just getting started. Click subscribe so you're always in the loop. Now here's where it gets juicy. You might be thinking, wait a second, we already had a case that trimmed agency power. Yep, West Virginia v. EPA. That case introduced the major questions doctrine, the idea that if an agency wants to make big policy moves, Congress has to be crystal clear about it. So, does Loper Bright make West Virginia v. EPA irrelevant? Not quite. It still plays a role in helping courts interpret what Congress meant, just without Chevron's automatic deference. Think of it like a flashlight courts can use when the text is murky. If you're loving this legal detective story, don't forget to subscribe and tap the bell so you get every update. Now let's switch gears. We've been talking about agencies' rulemaking power, but what about their judicial power? Enter the public rights doctrine. It says some matters like Social Security benefits can be handled inside agencies without violating the Constitution. But here's the kicker. The Supreme Court's decision in Jarkesy said some agency cases like fraud trials in the SAC are really about private rights. And those? They must go before a jury. Agencies are losing ground on both fronts, writing rules and deciding disputes. If this is blowing your mind like it did mine, hit that subscribe button, we've got more coming. So, what does this all add up to? Agencies can't count on judicial deference anymore. Courts are stepping in and reclaiming interpretive power. For businesses, this means more chances to challenge federal regulations in court. For the government, it's going to be harder to act quickly and decisively on complex issues like climate change, healthcare, and finance. And for you, the voter and taxpayer, this redefines the way power is shared between the branches of government. Is this a win for democracy or a roadblock to progress? You decide, but whatever you think, one thing's clear: Loper Bright is the most important administrative law case in decades. Before you go, don't forget to subscribe because next week, we're covering the court's latest take on AI and the First Amendment. You won't want to miss it. Thanks for watching, friends. Drop your thoughts on Loper Bright in the comments. Should agencies have more power? Or did the court get it right? Hit like if you learned something new, subscribe for more high-impact legal breakdowns, and I'll see you in the next one. Until then, stay sharp, stay curious, and stay informed.